Joining us, first of all. And welcome to our Bench to Market Talks. These are done in conjunction, between Biolocity, Georgia CTSA, and then Patent Institute at Emory, at Georgia Tech. So today we have a really interesting topic. We get a lot of questions about this all the time, which is, okay, is my patent good? How does it fare with, what's out there? um, you know, what sort of chances do we have of getting claims? And all those are kind of really interesting questions about um, just, patents and, intellectual property more broadly, right? Um, but it all starts with an invention disclosure. And as we've continued to have more and more conversations with teams and with resources in our community, um, you know, it made a lot of sense to have a conversation around what can I do as an inventor to improve, the quality of the invention disclosures that I am sharing with, my respective Office of Technology Transfer and Licensing at my institution, right? So thank you everybody for joining us. And without further ado, I wanted to just highlight real quick the upcoming conversations that we will have on these fronts. Our Bench to Market series is, pretty diverse in terms of topics, and we'll cover another conversation around IP more broadly. What happens after filing, and how should I think about the evolution of that IP in terms of other patents in the space, prior art. We'll have some conversation around FDA, regulatory filings, quality. So all these topics are pretty interesting for innovators in our institution, and also kind of beyond in our community as well. So another just punctual announcement, and one of our panelists, Nicole Morris, has gracefully helped us set these up. There are occasions where inventors just find themselves with questions around, okay, how do I navigate this particular issue in my context? And these are assets that are owned by the universities, and therefore it's always a challenge to get kind of formal legal opinion on these, and there's delicacies around that, and just maintaining the integrity of the patents and making sure that you don't necessarily get an opinion that could hinder that ability. So we have the ability to have informal consultations with Emory Law, and Nicole is gracefully kind of helping our teams and folks in our community navigate some of these issues in conjunction with the respective Office of Technology Transfers as well. So want to remind everybody, as you know, Biolocity is a BARDA drive accelerator. And we're actually getting a lot of interest, both from BARDA in terms of technologies and companies that are in our region, but also a lot of kind of inquiries from folks. So I entice you to go to the website, and even if things have potential from a Biolocity funding perspective, BARDA is very active in looking at some of these specific areas that you see here, but in general, about readiness in terms of bioterrorism and surveillance, countermeasures, and these priorities tend to shift over time as well. So they add kind of new topics to their areas of interest as well. As I mentioned, our upcoming talk, James Raines will walk us through some of the other aspects of intellectual property strategy on January 22nd. And without further ado here, I wanted to introduce three. This is just happens coincidentally, three of my favorite people in our ecosystem, Nicole Morris, Justin Burns, and Kenny Franklin. So Nicole is the director of the Tiger Program and professor of law in the Emory Law School. And she, for those that aren't familiar with the Tiger Program, it helps get technologies really ready for commercialization, similar to what we do, but it's a collaboration between, the business school at Georgia Tech, the law school at Emory, and then it brings in, scientific disciplines across both campuses. It's a formal program. Students can work on ideas and projects there that have true commercial potential. A lot of great resources on that front. And Nicole has a background in chemistry, law, and law, I might say. And both academic and teaching experience, but also industry related IP experience as well. So very relevant. Justin Burns is joining us representing Emory OTT. And many of you might know Justin, but if you need anything related to material transfer agreements, and have worked with him on a direct like technology management side as well on that front. But his background is in biology, microbiology, and he has a PhD in microbiology from Tech, actually, coincidentally, although he's at Emory. And then Kenny has joined Georgia Tech slightly more recently, but has a lot of industry experience on the intellectual property front, and is also JD MBA, so interesting. Has a background in chemistry as well. So I'll open the floor for you guys to maybe talk a little bit more about your perspectives, and then we will have more of a panel discussion. You guys can put in some questions in the Q&A box. We'll make sure we read those, and we'll have them kind of jump in between topics and comment on your areas of interest specifically. So thank you so much, guys, for joining us. Really appreciate it.
Yes, I will kick off our comments today. I want to add a somewhat known fact about Kenny Franklin. He's also a graduate of the Tiger program. So whoop, whoop. We've got some alums in the house. Good afternoon, everybody. Thank you for joining us. Your life on Zoom or some other video conference setting. So we appreciate you coming and giving of your time. I looked in the participant sort of window, and I see we've got some familiar faces that, to me, in the Atlanta area, and then some innovators across both campuses. So thank you for joining us. I want to say congrats to the innovators, because if this is a topic of interest to you, that means you actually want to submit a high quality invention disclosure. You have something that you believe warrants submitting for a patent filing. So congrats for whatever you're doing out in the innovation space. We don't have any slides because I wanted this to be more conversational, and also to encourage you to submit questions to us. So I'll start off with some remarks and kind of kick it over to Kenny and Justin to share what they consider probably are best practices for innovators coming to them wanting to get the university to file a patent application. My remarks will be applicable to university innovators as well as private sort of industry folks. And one of the things that we focus on in the Tiger program for the students is really looking at taking whatever technology innovation you're working with and taking one step back to focus on the problem that technology addresses. So the problem and your solution should be part of that conversation and part of your thinking as you prepare the invention disclosure. Some invention disclosures actually require you to fill out a box or fill out on the disclosure form itself, some discussion on that, but really focusing on validating the problem, I think, is one of the critical pieces that most innovators don't think about. And it's important because in validating your problem, you're able to think about it from the user, consumer, purchaser perspective, right? So if your solution's going to be in a product, well, who's going to buy that product? And how are they currently addressing the problem now? And what makes your solution so compelling that they will shift to your product or your offering? And I know it sounds really wacky as a PhD microbiologist or a chemist or mechanical engineer who's come up with this really great new technology that I'm asking you to think about the end user. But the point of filing a patent application is to protect the invention because you want to sue somebody or you want to enforce your patent rights. And when you get to the enforcement stage, all we care about is the product that the patent or the invention is disclosed in. So the journey is a really long one, But at the end of the road, we're going to be looking at that product, right? So for those of us who, I'm sure everyone on this Zoom remembers Samsung, Apple, and the iPhone wars, what they really cared about was what the device looked like, what Samsung's device looked like compared to the Apple device. They didn't really care about what really cool, innovative engineering doohickey the inventor had at the front end of the invention disclosure. So thinking about where your invention might wind up in terms of the product and what the consumer would be interested in becomes an important part of the invention disclosure process that most people really intuitively don't think about. And if you do put some thought there, I think that will lead to higher quality, or at least better informed invention disclosures, and one that will get the guys who are going to turn to next, Kenny and Justin, one that will get your office, tech transfer office, excited because they're like, they see either monetization potential, licensing potential, collaboration potential, or some other potential other than just the really technical description of what you're pursuing in any future patent filings. So I'm going to stop there because it's quite a bit of talking, and open it up and say, Kenny or Justin, I'm sure you guys have some invention disclosures sitting in a queue somewhere in the office. What do you do when you first get that disclosure from the innovator? And I'll just pass the baton generally to either of you to pick it up.
Kenny, I feel like it's a race to see who's going to unmute first. So thanks, Nicole. I think that's a great synopsis. One of the best scenarios I like to give is a little bit of hyperbole, but it's always like, especially at Emory, where most of our innovation is focused in healthcare, is an inventor who describes a new cure for polio, right? It's a great new cure, but nobody gets polio. So we have to look at it from both perspectives. It may be a really cool scientific finding, and it may be something that's very applicable, but it's not necessarily commercializable, right? So think of it in that case, right? So we don't get invention disclosures describing, new cures for polio because nobody really is working on that anymore. But I present that as sort of a challenge to all innovators to say, make sure that we understand what the real unmet need is. We want to make sure that we understand where your potential invention can go. We don't claim to be experts sort of necessarily in your particular field, but if you highlight to us exactly where the unmet need can be, we can certainly help you find a way to move your invention forward. And then it helps us focus our search and make sure that you really are coming up with something that hasn't been discovered before, or even if it's something related to a previous discovery, how it's different from what's out there already. Maybe Kenny, if you have other thoughts on something like that, that's a little bit of hyperbole on my part, but yeah, definitely, I think most invention disclosures, getting things in that field will help us move forward.
Yeah, I agree with everything Justin you just said, and I actually and Nicole as well. I was making a note, Nicole, as you were talking to about the way you articulated describing the problem and the solution. And one of the things I wrote down to kind of go along with what Justin was saying is, is the problem you're solving, is it an academic problem or just a scientific, or really not invaluable, but a very interesting problem in that regard? Or is it a market problem, a customer problem? Is there something out there in the market? And that's key, because both types of problems exist and sometimes they overlap. And sometimes, in fact, maybe a lot of the time, the technology that an inventor has solves the problem that they think exists, but there may be other problems it can solve as well that they haven't thought about. So I would encourage folks, and that's part of the evaluation process that our office will eventually go through as well. So it's not to put all the work on the inventor, but the more that he or she can kind of use their imagination and do some of their own market research and think about what's happening in the market and how their technology relates to that is helpful to us. And I really like this whole problem versus solution framework because, and I know in our invention disclosure at Georgia Tech, we start off by asking for a brief description of the technology or of the invention. And I'm wondering, I may actually go back to my team and suggest that we amend the disclosure to ask, what is the problem you're solving and how did you solve it? Because I think that's an easier way to frame the question in a way that is going to be meaningful for us and our purposes.
Yeah, no, that's a great point. And I think a lot of innovators are comfortable describing the technology. They'll pull an abstract from a paper they've written. And I've seen many of these technology descriptions full of, technical jargon and, it's dense, complex stuff. And it's great stuff, right? It shows the expertise and intelligence of the innovators submitting it, but it becomes really hard to translate that into a meaningful starter for a patent application. And I think that's the hardest part. And a lot of the innovators we work with at Tiger, they'll come and they'll say, well, we don't know how to do that, right? I'm a trained PhD chemist. I don't know anything about the market. I don't know anything about, who a potential customer could be. And I love Justin's example, right? So if you come up with a solution and for curing polio, well, who gets polio anymore, right? Like, so you do know that, innovator, right? Like, name us a polio patient we could give this to, right? So you could just think about it from your knowledge of that technology space, right? So we're not asking you to do some high level market research that we could put on an MBA student, right? We're really just asking you to say, if I gave you $1 million tomorrow and you had, all the manufacturing capabilities, where would you go with this, right? So if you could quickly get to market, how and who would be interested in receiving this product or solution or whatever. But your point about the academic solutions, since we are all of us employed by these wonderful academic institutions, probably to another thought. So when I was in private practice, I would frequently suggest to innovators when we couldn't really get to why do you need a patent, I would suggest to them the alternative of filing a patent, which is a defensive publication, right? And for most of the consumers or the stakeholders that we serve in the university, it's a publication or peril type of employment, environment that you live in. So you're already comfortable writing an article, putting together a publication, technical publication. Some of these academic solutions are on the fence, right? So part of the problem is if you disclose it in that paper, then you can't file the patent application. But if you disclose it in the paper, no one else can file the patent application because it now is public knowledge for everyone. So how do you guys deal with that quandary? One of the good news about my job is I just go, I don't know, go talk to the Office of Tech Transfer and let them figure that out. But how do you deal with those really theoretical discoveries that are phenomenal, right? I can think of CRISPR as being something similar to that, where it's like, this is some really cool tech, right? Like, this is revolutionary stuff. We don't know if it'll ever work in making a drug, but this is a phenomenal discovery. How do you treat those in terms of whether or not you want to pursue a patent or just pursue academic publications?
So we certainly look at those and see, I'll bring up one other point, which is we recognize now that there's a lot of push to put into preprint servers, right? So even before the publication may come out, there's these preprint servers where people want to go out and sort of get a publication in, even though it's still under current review. Generally speaking, and Kenny, feel free to weigh in from Georgia Tech side, but we're happy to operate within the lag time, right? We understand that there's a time period between when you submit a publication for review that ultimately will get accepted. And we're happy to operate within that lag time to sort of review the technology, find a way to make sure that there's an opportunity to protect something if there's something to protect. But we have to understand what the technology might be. We have to understand how applicable it might be. So obviously, the more time we get, the better. But we're generally comfortable operating within that lag time. When we have something new that's sort of like CRISPR or some other new and cutting edge technology where even the application of it might be uncertain at the time we receive a disclosure, that's okay. At least in our office, most of the people reviewing these types of disclosures are PhD level scientists. We're people that have been in the lab. We're people who have published. We understand what you're up against. We understand that you may have a graduate student who's going to defend, in a couple of days, even if it's not something that's going for publication, but it's still going to be put out to the public, right? And we understand it's not necessarily ready for prime time. The benefit, and Nicole, feel free to correct me if I'm wrong, but if the benefit of patents is we don't have to sort of put in error bars, and N of 1 is okay, right? So we're not here to sort of ascertain whether the data are accurate. If the data show a result, we can file a patent. The data that say a technology works, the patent office is not there to sort of review your data unless there's something else out there that sort of refutes it. And so even at the time you have the data, it's better to get something on file than it is to sort of wait until you have standard deviations and standard error and all those sorts of things. It's one of the things that was really difficult for me coming from the science side into a tech transfer realm, which was my job. My job here is not to poke at your data and sort of poke at your error bars. If you tell me the data is good, I believe you. We will go forward and we will move forward on a patent. And that's a real benefit for our side. And Kenny, maybe you have the same mentality as sort of, we believe data that come into our office, right? We're not here to be peer reviewers.
That's a great point. And Kenny, I'm just going to add some comments and I want you to share your thoughts too. An N of 1 is acceptable, right? Yes, right? And it's acceptable to the patent office. So I teach a case study on Theranos with my students and they get really upset. Professor, how could the patent office have granted Theranos a patent? Blah, blah, blah. Well, the patent office will never review for commercialization potential. They will never review for, is there a product at the end of this rainbow, right? They're just looking at the data submitted in the filing, and it can be, prophetic examples, right? Which means it's a paper example. There's some data, but there does not have to be a box. The Einstein, diagnostic tool did not have to exist at the time of the filing. So I try to let students know that it's not the job of the patent office to verify whether or not this invention is commercially viable. And it's nice to know that on some level, the Office of Tech Transfer is looking at it with a similar lens if the discovery is compelling enough that we should protect this with a patent. Kenny, what are your thoughts?
Yeah, so, a couple of things. The more data, certainly the better. That can only, it can only help as long as it's supporting the fact that the invention works. But in general, data is not a requirement of patentability exactly, right? So you can come up with invent a machine that you haven't actually built. And as long as we can describe it in a certain sufficient level of detail and what we call enablement, that can be patentable. Data becomes very helpful, and in some certain technical areas, the data does become critical. I think especially in some of the biomedical space and pharmaceuticals, being able to show enablement in those cases. But if it's early on and there's not necessarily that much data yet, we still may have patentable information and patentable subject matter. So it just really depends, and it's a case-by-case basis. As for publishing, we are not ever attempting to guide what a professor or a researcher wants to do in terms of their publishing strategy. We're not here to stop it or tell them, no, they shouldn't publish yet or anything like that. And I think what would probably help is to just explain kind of where an office like mine fits into the broader picture of what the university does. And Justin, maybe I'll be curious to see if you look at it the same way on Emory's side, but the way I often describe it to folks is that, the general purpose of a university is dissemination of knowledge, right? And improving society through the dissemination of knowledge. And when you look at actual university mission statements, you'll see a lot of things that kind of articulate something like that. And knowledge gets disseminated by teaching students, by going to conferences, by publishing like we've been discussing. And all of that stuff goes out to the world, in theory, for the benefit of society. And what we also realize, though, is that one of the ways we can disseminate knowledge in a given instance might be to not only publish about it, but to also do certain things that make the intellectual property economically valuable. Maybe the best way to disseminate that knowledge is to get it to the public is to do it in the form of a product or in the form of a service. And so we just, I just look at tech transfer and tech licensing in the university setting as kind of this one component of the wheel of knowledge dissemination. And in this case, it's just situations we're identifying as being suitable for a commercial path instead of just maybe a more academic path involving publishing or going to conferences. And so what we tell inventors on our campus is, we don't want to ever stop you from publishing, but if you are going to publish, and if you do think that you have something that may have this commercial potential, then try to let us know first. Because if we file, and we can do this very, very quickly within a day or so, we file very quick provisional applications, and we're very liberal about doing that if there's about to be a publication, if we need to. That will protect the most potential rights that we can if we file before public disclosure. And one of the things folks should understand is that if there is a public disclosure and we file afterward, that limits our rights in most of the world. We actually still have rights in the US and in a handful of other countries through what's called a grace period. But we just tell inventors, look, if you're going to publish, that's great, but just if you think it's valuable, let us know and we'll try to get something filed first. And then we'll evaluate and go to all these other questions about, all right, well, how commercial ready is it? What else needs to be done? Does it have a market problem that it's solving? How early stage is it? Sometimes we do file patent applications for things that are very early stage because we think that the market is developing, but will be more mature in a few years down the line, and we want to plant the flag, right? So it really just depends, and it's a very fact-specific analysis.
Yeah, just to add to Kenny's comments, so we typically are happy to sort of review things, and again, we're not here to stop publication. The only exception to that being if you were happen to be already working with a company, right? The company may want to review what you're publishing and review it for something that may be patentable. So if you have an industry contract, for instance, where you're getting money from a company, you want to let somebody know ahead of time before publishing. It may be in the contract, and you may need to require, maybe some requirement that you let them know, because there could be something patentable. Even if you don't think there's something patentable, the company may wish to protect it. Or at least plant the flag, like Kenny said, because at least at the time you want to publish, it may be unknown whether how commercializable it would be. But yeah, we're in very much the same mindset, which is if something is ready to go and ready for publishing, we're not here to stop you. But if you think, or if you even have an inkling that there might be some commercial applicability to it, give us a chance. That's part of our job, is to look at it, right? And so even if it's a grant application or something where the invention might not be clearly defined, right? So even if it's a therapeutic, or maybe there's a potential for diagnosing something, right? Part of our job is to look at that and say, you may have actually one or more inventions described in that grant application. It doesn't necessarily have to be something you flesh out yourselves, right? So we can look and see what's contained in that publication, find a couple new things, talk with you, and have a suggestion about how to move forward. So yeah, we're happy to operate within your lag time. I generally give inventors the example of, by the time you've put together one of these multi-panel figures that is going to go in your publication, you've already generated all the data that we would need to make an informed decision about what the invention could be, right? It doesn't have to be something that's fully fleshed out. We don't need a manuscript that you're submitting to Nature or Science. By the time you put those multi-panel figures together, that's generally enough information for us to work forward and find something new, or at least give you some educated evaluation about what the commercializable potential might be.
That's great stuff, you guys. One of the things that I wanted to note for the participants and just generally with this conversation today is one of the sharp differences between university invention disclosures or innovation in a university setting versus innovation happening in the sort of private sector, where you really are looking at some pretty early stage discoveries. Versus in the private sector, you might have some early stage work if you're like a biotech company or something like that. But generally, your R&D teams are focused on what I would call follow-on innovations, right? So you have product in the market, you've got teams looking at either disrupting some of that, but you know the market, right? Or your follow-on to a line extension or something that's already or existing in the market, and you're going to further support that with a new product offering, and you're pursuing patent protection for that. But the universities, we're looking at innovations that are, you have no idea that this is going to take off, right? You're just sort of, it sounds great. My scientists are super excited. They're convincing me that this is a must file, and we're filing it, and we see where it lands, 5-10 years later. So that's part of the challenge with this conversation and trying to figure out what do you do and how do you handle that. We talked a little bit about non-provisional versus provisional, and I think it might be helpful to just explain some of that strategy, and it would be nice to get your thoughts on that. So provisional patent applications are what I call kind of a timestamp, right? So you file it to get it into the patent office, so the office knows you are the first to, discover this technology, this innovation. It's not reviewed by the patent office. It is just a filing that says you're the first to do this. It's like a flag in the ground somewhere, right? You've discovered this new territory, and you have a year to then decide if you want to follow that up with what we call a non-provisional application, which is the real patent application that the office will look at and examine and then later issue. If you're doing global filings, you have that same year to then file your PCT application, which would then kick off your global opportunities if you want to file outside the US. And then there's some other timelines that you need to think about for when you need to do your US and your foreign filings. And I don't have those committed to memory right now because I don't do that work anymore. But when you're looking at some of this stuff for your university innovators, so back to Justin and Kenny, give us some thoughts in terms of how do you always just sort of default to provisional? Are there cases where you might think of a different filing strategy based on the disclosure? And we've got some great questions in Q&A, so we'll open that up in a few minutes here to get that going. But any thoughts on filing strategy?
I guess I'll go first this time because Justin's been brave on the last couple of questions. Another one I'm really curious to hear from Justin about, actually. And for everyone's information, Justin's office and my office, we work very closely together on a lot of technologies because of all of the collaboration that goes on between Georgia Tech and Emory. So we have a lot of jointly owned intellectual property between the schools. But it is interesting for me to hear about inventions that are not jointly owned and just ones that you guys are doing, and how you look at some of these issues just kind of in your own silo. But on that question, so we at Georgia Tech in our office, most of the time we are filing initially a provisional patent application. It is usually the way we do it, it's a lot less expensive than filing a full-fledged non-provisional patent application. Now, that comes with advantages and disadvantages. The advantages are it's less expensive initially, and it gives us a lot more time to really evaluate whether this is something to then spend a lot of money to start filing full non-provisional patent applications on. And a lot of times, we need to file a provisional application quickly because we'll get an invention disclosure that says, hey, this has been accepted for publication and it's being published online, within the next week or something. We have to, if we want to preserve the most rights, we got to try to plant the flag. And so expense and being able to do it quickly are the main advantages, along with kicking the can down the road in further resources and time. So the potential disadvantage of a provisional patent application, most of the time what we're doing from an expense point of view is filing what's called a cover sheet provisional patent application, which means we take whatever materials that the inventors have given us, whether it's a copy of a manuscript, pictures, descriptions, lab notebook page, scans from a lab notebook, whatever it may be, and then we basically put that together and we just file that with a cover sheet. And that's a pretty inexpensive way to do it. On the opposite extreme, you can file as a provisional application something much more extensive, all the way to something that's equivalent to a non-provisional. And that's something that's many hours, many thousands of dollars. It goes into a lot of detail and jargon that's used in the patent world to that makes sense for patent application drafting rules and that sort of thing. And so we can't file a non-provisional level application for everything that comes in and for everything that's about to have a public disclosure. We just don't have the sort of resources to do that. So, we're making a judgment call and saying, in order to preserve rights where we can, we're at least going to file a cover sheet application. Now, the thing to remember is that the application gives you that flag in the ground, but it's only for what is contained and what's enabled in that application. So the question is there enough detail that someone of skill in the art can go and basically recreate your invention without undue experimentation? And there's a lot of, gray area words there. But that's basically the standard. And if we go and we file a cover sheet provisional and a year later we file the non-provisional and add new stuff in there and add new embodiments, then those will not be covered by the original filing date. Those will get a new filing date for purposes of the examiner, the patent office, doing prior art searching and seeing what would count against you from a date point of view. So we just do the best that we can. Sometimes we will do something more extensive in the beginning if we feel like, if we have a licensee that's like they're ready to go and we want to file something on a provisional basis, but we are making a bet that, look, it looks like we're going to get this license and get this reimbursed. We want to make this as commercially viable as possible, so we will get something more extensive drafted. So it does depend, but that's generally the strategy, because we really want to, we are a state university. We have to be good stewards of the funds that we're using. And so it's a judgment call and kind of filing what we can to preserve the most rights and buy time to then really put the resources into the things that we think are going to be licensed and have that commercial value.
Hey, Justin, I want to jump in here, just give me a little courtesy on sort of this legal point that Kenny triggered with how much data, like what kind of data and how much data to include in the provisional application, and what that will do for you in terms of claim scope and claim scope protection in the non-provisional. So legally, the requirements for a patent, you must have something that's novel, something that's non-obvious, and then you have to have a sufficient written description. So there's three sort of the legality of your filing that the office will look at. And if we had a patent 101 seminar, we would talk about all of that in a nauseating detail, but we don't have time. But I do want to focus on just that written description part, because that becomes critical with at least the provisional filing strategy. And what that says, and Kenny, your words that you used were undue experimentation, right? So the law requires all inventors to disclose enough information that another super smarty microbiologist could pick up your application and go, oh, I know how to make this bacteria, versus that super smarty person going, I have no idea how to do this. They didn't tell us anything. I don't know any parameters of that. I would have to do a ton of work, a ton of experimentation to actually reproduce these results. So the amount of data you need to include is somewhat of this sliding scale, because the test is enough that someone, a peer of your technology, would pick up and read your information and know how to make and use the invention. So I know that doesn't feel good for the non-lawyers on this Zoom. And for the lawyers on the Zoom, we're like going, yeah. Sometimes I win. But that's the test. And it's a little bit flexible, right? It's got some expansion boundaries on what that would look like. And it's not a really strict analysis. And you'd have to take it on a case by case basis. But it can't be super thin, is basically the point. So your provisional should have enough. I've worked at organizations where the provisional was nothing more than the abstract from the paper and the cover sheet. Those were usually the emergency cases where it's like, we have to get this filed in the next 24 hours. I've worked on cases where the provisional was a lot more detailed, lots of experimental data, maybe 1 or 2 claims, right? Which is nice. And usually what I would advise with some of the innovators that we come to, it's like, I want every bit of data you have, and I'll put that in the provisional, right? Like any experimental work you've done, all your data. And even if you haven't characterized it yet, I just want the data, because I could then explain later in my non-provisional using your data to establish why I think I have rights to that claim scope, why we disclosed this in the invention originally, and what your data really means. So I'll stop there, but that was a nice way to sort of provide some of the legality. And after Justin, you sort of share your thoughts on filing strategy, I'm going to the Q&A. So if you have questions, put it in the Q&A. I'm going to the Q&A.
Okay.
Thanks, Nicole. And I wanted to give a little bit of perspective on the difference between Emory and Georgia Tech. Emory, as I mentioned once before, we have sort of 90% of what we see is some way healthcare or life science related, whereas Georgia Tech maybe doesn't have that benefit or detriment if you view it that way. And so we actually have 2 in-house patent attorneys that sit within our office, and we are able to actually draft and file things internally rather than going to outside counsel. So if there's an opportunity to file something new, the best thing you can do for Emory's perspective is to give us more time. We can certainly get those in hand, and it costs us very little money out of pocket. We don't have to go to a law firm to sort of ask them to file something. We can actually get our patent attorneys to review things, draft them, draft a fully fleshed out patent application that fully and adequately describes the invention that will stand up to that rigor, even when we plant the flag in the ground, right? So obviously, if we have something coming in that's going to be published, we want to do the exact same strategy, which is to say, this is what we have at the time the publication is going to be made. Here's where we think, our invention is. One of the biggest challenges we have, of course, in doing that is academics like to publish manuscripts that include a discussion section, right? And so the discussion section often includes terms like, this suggests that, X, Y, or Z will be beneficial. We take those out. We go in, we take out those things from your manuscript because we don't want to in any way invite the patent office to say that at the time we file a cover sheet provisional, that we didn't possess the invention that's encompassed in that provisional. If we include those types of phrases that say, this suggests that things will work better, or this suggests that our new molecule will cure cancer, that tends to lead them to believe that we don't actually possess the invention at the time we file that provisional. So generally what we file when Kenny's talking about filing a cover sheet with your manuscript is a description, the abstract, the materials and methods, the results and data that show what you generated works in the way you say, and the data support that you've enabled the invention at that time. That's the best thing we can file if there's a manuscript imminent. If we have a bit of lead time, which is sort of what I alluded to before, is when you're starting to generate those data and have these panels and figures. If we have an opportunity to draft a patent application instead of just filing a manuscript with a cover sheet, then we could actually generate what is the equivalent of a non-provisional application at the time we file the provisional. That becomes important because if you file a manuscript with no claims, the invention is actually described by the claims, right? So if you've ever read a patent application, at the very end of it, most often it says we claim, and it sort of describes at that point the invention, right? So it describes a small molecule that has this composition and this structure, and then later on it'll have a bunch of other claims that say, and using it and doing this and preparing a pharmaceutical composition. So we want to make sure that if that's the invention you're claiming, we get that stake in the ground as early as possible. The benefit there is that if you go on and sort of either modify it or do something later, we have that stake in the ground. As Kenny alluded to, if you put that stake in the ground early, and then by the time you go for that year-long period, and you publish or file the non-provisional application and add new things, right? So let's say you submitted your manuscript and maybe it wasn't published and you updated a few things, or even if you published the manuscript and you found new molecules or new things, right? We'll only get protection to the extent that they were claimed in the original provisional. So if we file a new provisional and in the intervening time you published or presented something publicly that talks about a new molecule or something, we lose the benefit of that year-long protection, especially outside the US. So we may still be able to get some claims to things inside the US because of the grace period and a few other jurisdictions. But generally speaking, if we're looking to commercialize, we want the US, we want Europe, we want a few other jurisdictions. And so we lose the ability to protect it in those places. So generally speaking, the long story being, the more time we had to prepare a patent application, the better. So if we certainly understand if you're called to give a late breaker abstract at ASH or something, some other important conference, and we need to file something, we will certainly do so. We will protect everything we can. I think that's generally true both from Emory and Georgia Tech. But generally speaking, the more opportunity we have to include more things and draft it better, the better off we will be in the long run.
That is super helpful. Yes.
Can I just add 2 quick points on all of this? I know we need to go to the Q&A, but let me just make 2 really quick points because I made some notes. I really want to drive this home since this is about high quality invention disclosures. One thing to remember is that, and this actually does come up on occasion, the disclosure to our offices, okay, Justin's office or my office, is an internal document with our university. It is not a filing with the patent office. It has nothing to do with the patent office. I do on occasion get inventors who filed an invention disclosure and thought that they were preserving patent rights through the invention disclosure, but it's not. It's like if you worked at a company and disclosed the invention to your in-house legal team, the USPTO, the patent office is not involved. So just know the difference between that, and that if you do need something filed with the patent office because there's about to be a public disclosure or a public use of the invention, you make sure you let us know, because then we need to do the other things to do that. And then the other point I want to really drive home as well is, aside from all the things we've been discussing about what's patentable and what's commercializable, there's a lot of other questions in the patent application, in the invention disclosure, and they're all there for a reason. And so I want to encourage everyone, when you're filling this out, to really read these questions very carefully and give us as much information about the question as you can. Everything from just who the inventors, or if you're writing code, who the authors are, their contact information, are they employees or students? We need to know these things. Things about how the time and work and obligations used for this invention were funded. Was it internal state funds? Was it a sponsored project from a company or federal agency? If so, what's the project number? Like all of these details. If there was a public disclosure question, don't just say it was disclosed at a conference in June. We need to know the date, and we need to see a copy of the presentation. So the more that you can really divulge for all of these different questions, the better it's going to be. We're a very, very high volume office, which is good. I think that speaks a lot for Georgia Tech, and I think the same is the case for Emory as well. And the more of that information we have up front, those are all critical questions. To go back to one of Nicole's earlier questions as to what we do right in the beginning when we get these disclosures, we're trying to figure out, does Georgia Tech have ownership of this IP? What are the funding obligations? Who are the inventors? Are there any third-party owners? Is there third-party intellectual property involved? Did you use third-party software libraries in the code that you are disclosing to our office, which has an open source license attached to it? So there's all different sorts of things, and it's really important to get as much of that info from you as possible. That will definitely make things a lot easier.
That was super helpful. Yeah, there were some thoughts I had about the information that you collect, regarding funding, federally funded, projects and things like that. And all of that information should be in your invention disclosure, particularly if you're filing it through a university, because that's important to sustain federal funding for grants and things like that for the university as a whole. So definitely think of that document as being one that you want to be the most honest and transparent with. And if you are under a time crunch, that you let the respective office know that you need to, get some things on file soon. And it's not a filing with the patent office. So it's really an internal disclosure, and it's not a public disclosure. So let's see. One of the questions that I think is a useful one is if the University Tech Transfer Office declines to submit the patent application. So inventor submits an invention disclosure, you review it, and you say, we're going to pass. Can the inventor have the opportunity to submit the application on their own?
So there's probably two very official answers to this based on whether you're at Emory or at Georgia Tech. The short answer is that if you submit an invention disclosure, the best thing you can do is to submit an invention disclosure, right? Because you don't want to go off and file it on your own. Each university has an IP policy that says if you're an employee, we sort of own the IP that are generated while you're here. There is an opportunity, at least at Emory, for when you submit an invention disclosure and we review it, and we think that either at the time you submitted it, there's not enough to move forward, or we think that there's no justification for moving forward. So let's say in the extreme example, like I gave before, is you have a new cure for polio and we say, listen, we just don't think that we're interested in this right now. The faculty member or the employee can submit a petition to have that released. That release will be subject to a number of other things, right? And we can only release the rights that we have. So if you are just a sole inventor, you're the only person, Emory would own the rights. We can certainly release those to you. The only thing that I'll say is that if it was funded by the government, there may be government rights that are subject to that release as well. If it were jointly invented, either with somebody at Georgia Tech or independent inventors, we can't release their rights. So you may still have a joint inventor who may own a portion of that patent as well. There is an avenue for doing that. For all Emory inventors, I would encourage you just to sort of reach out to your respective case manager or to the OTT office in general and make sure that if you have an interest or think that we're not moving forward, generally we have a pretty good reason. We do a pretty thorough evaluation of the technology, making sure that we've explored everything that's there. If we really feel that there's no opportunity to move forward, we've hopefully communicated that to you and get your opinion on that. And maybe there's something we missed. We take no pride in being wrong. So if there's something we missed that sort of enlightens us to help us move forward, it'll let us know that as well. The general decision for not moving forward is not one we make easily, but we certainly want the inventors to be part of that discussion.
Yeah, I it's very similar with us as well. We don't call it a petition for release, it's a request. We do have a GTR, Georgia Tech IP policy in the handbook, which with Google Georgia Tech IP policy, you'll be able to find it pretty easily. That lays out that process. Almost the same thing. If we decide that we're not going to commercialize the IP, you can request the rights to be released. And we'll do it if we're able to do it, if we have no obligations to the contrary. There could be various caveats depending on the situation, but that's effectively the policy.
So in the interest of time, I'm going to take one additional question. Thank you for these great questions, you guys. It's been super helpful. This one sort of relates directly to invention disclosures. So the question asks if there's like a standard that you use to justify whether or not the commercial potential of the patent. So are the inventors expected to conduct detailed market surveys? My guess is no, but I want you guys to share your thoughts. Or any anecdotal expression of interest from potential customers sufficient? I think any interest from potential customers would be fantastic, and you should definitely include that in the invention disclosure. But how do you guys think about what you would want to see from the inventors as they're looking at the market and what they should put in the disclosure?
So I think generally the market is not something we feel helps us justify a patent or no patent decision, right? So even if it's a small market, if it's a rare disease or if it's something like that, that's not going to help us decide to move forward or not. We want to make sure we have a clear IP space. We want to make sure that we can attract interest from a commercial party to move forward. Having customer interest is an interesting concept. Customers that may be interested may not have a good feeling for what's out there. But at the same time, having, again, like Nicole mentioned, is having somebody interested in the product is always a good thing. So if you had, even at the basic science level, you had somebody, willing to come in and say, listen, if that were on the market, I would buy it. That's great. Who wouldn't want that, right? The other thing that opens up, of course, is that you may end up finding a donor or finding somebody who's willing to fund the research, even if the product at that point is not ready for prime time. If you have somebody saying that's a great thing, if only it could move forward, maybe there's an opportunity to get some additional interest and resources to help move that forward. So in general, having customers that are willing to buy the product is great. Our job, at least in tech transfer, is to make sure that we protect an opportunity to get additional investment, especially if you think in terms of therapeutics. It's going to require significant investment to get to market, right? It has to go through regulatory approval and otherwise. So having that initial investment, even from customers, is a great way to sort of incentivize the tech transfer office to move forward. We will still sort of conduct the independent evaluation and see, is there a path forward? It could be even with customers interested, somebody may have a patent out there that covers what you're looking for. So in that case, sort of we still have the hard decision to make. But again, we would hope to make that decision alongside the inventor and not sort of have it be unilateral from our office.
And I'll just say, the market is, for our office, it's definitely one part of the overall equation, aside from is it something that can be protected in the first place. We do look into that as part of our evaluation. But the more info you happen to have, if you can look and tell us about the market and give us some info, the better. We do have some questions about it on the invention disclosure form. If you have that info, that's great. The more the better, but we will look into it.
So I wanted to jump in just for the sake of time. Guys, thank you so much for sharing your thoughts. I think this topic is super interesting and useful, and we can go on for a pretty long time. And Nicole, thank you so much for moderating. You're definitely all the type of guests we love to have on the show, right? One thing I will say in general is make sure you view your technology transfer office as a partner. Approach them with time, kind of have the discussion around planning and thinking through issues. And then they're kind of expecting what you're going to deliver to them. Don't necessarily see them as, on the other side of the fence, right? You're part of the same institution. So you will learn a lot. They'll get to know what you're doing better. And then, they'll be able to help you be successful. And then, the institution overall will be more successful as well. So thank you so much, guys, for joining. And seems like we had a lot of good interest in conversation questions here. So